The next case is Westlake, Anderson versus Westlake. And I know our bailiff Kit has already spoken to the appellees. Have you decided how you're going to divide it up? I should have asked that the other people too.
Yes, Your Honor, we're going to share the time equally,
Okay.
and Avon will be arguing first.
Okay, sounds good. So, as you both know, you'll have 15 minutes on both sides, and the appellant, you may reserve up to 5 minutes if you so choose.
Thank you.
We are videotaping. I don't think there's going to be a reason why you'll be mentioning any victims or any children's names, but
Understood.
just trying to make sure I say that every time. Okay, we're ready to proceed.
Thank you.
Up front.
Oh, I'm sorry, I forget that.
Is that sign?
It's okay. I should have told you it was the front.
May it please the court, counsel, Nick DiCello on behalf of the appellants, and I would recognize that two of the plaintiffs' appellants are here in the back of the courtroom this morning. I would like to reserve 5 minutes for rebuttal, please.
Thank you.
And I always feel compelled to say that I try not to be repetitive in these oral arguments. I encourage the court's questions and look forward to responding to those. And I think it makes most sense to address the city of Avon claims first. As I understand, counsel for Avon will be arguing first on behalf of the appellees and then move on to the Westlake defendants. I think it also makes most sense chronologically, Your Honors. The lower court below granted summary judgment based on political subdivision immunity on behalf of the officers. I think my colleagues would agree the primary issue before this court is whether or not there is a question of fact as to whether any of these individual officers acted recklessly, willfully, or wantonly in connection with this high-speed chase. The facts of that chase are set forth in the briefing. The briefing on both sides is robust and complete. There is a fully developed record for the court. But just some factors that we find relevant in this analysis, which we submit is a very fact-intensive and fact-driven analysis, as these cases are. And finding direction from previous cases of higher courts and this court is, of course, appropriate. However, there is no case that is on all fours with this one, not surprisingly. This case involves a very unique set of facts, both from the chase side. When I say the chase side, I'm referring primarily to the Avon defendants, who was the agency responsible for this chase. They initiated it, and they were conducting it as it headed into Westlake. And the policies that we've submitted for the court's review, consistent with national standards, would require that that agency continue to control that chase. And when we get to the policy violations on behalf of the Westlake defendants, we'll see specifically how those policies outright prohibit explicitly the conduct at issue wholesale on behalf of the Westlake defendants. But with respect to the Avon defendants, the case law requires the trial court and this court, pursuant to its de novo review authority, to consider many factors. They're referred to as the Hoffman factors. The Hoffman case sets forth non-exhaustive list of factors. This is a totality of the circumstances review. Those factors are not determinative, and no one single factor carries more weight than the other. Another reason we think militates in favor of giving a jury the opportunity to weigh these many variables and factors. The factors that we find relevant that raise genuine issues of material fact as to the Avon defendants, that there was reckless conduct potentially here. And I always want to remind the courts, we are not, despite what some statements in the appellee's briefing, we are not seeking a ruling as a matter of law. We are seeking the opportunity to allow the community to weigh in on these questions. And the case law is robust in terms of questions as to willful, wanton, reckless misconduct are ordinarily questions of fact.
Counsel,
Yes.
let me stop you.
Yes, Judge.
you keep referring to reckless, wanton or willful. It seems like the appellees may be arguing that it's only willful or wanton.
With respect to vicarious liability on behalf of the city, I concede that argument.
Okay.
But
So
I think
it's willful and wanton if, well, either way, if the officers are found in the course and scope of their employment, the political subdivision is going to be paying regardless.
correct.
But, so you're saying for the legal analysis, it's willful wanton with the subdivision.
Correct. It's an important
And
distinction.
it can be reckless with the police officers.
Correct, Judge. I think you stated it. My position is what Your Honor just stated, that with respect to the individual officers, reckless conduct will pierce the immunity veil, and I suspect there's no argument that they're within the course and scope. They would be indemnified by the city to impose vicarious liability on the city itself. You're correct. It is a willful or wanton analysis. With respect to the factors, the chase factors that we have in this particular case, a 5-mile-long chase. There's no dispute it's a high-speed chase, 80 miles an hour in a 35-mile-an-hour zone in a densely populated area, the major thoroughfare through the city of Westlake, at night, but not so late that it wasn't busy out. In fact, my clients were at a local neighborhood tavern watching Thursday night football in a crowded restaurant, feet off of the street where this occurred. The fleeing suspect, as well as the officers from Avon, crossed the yellow line many times. I'd encourage Your Honors to watch the video. The chase went through red lights, through intersections, off the road, through ditches, and officers followed the fleeing suspect off the road, through a ditch, through a parking lot of an open delicatessen that was open to the public. They were chasing this suspect because the suspect committed nothing more than a property crime. A stolen old pickup truck was the crime that was suspected. He was not thought to be otherwise dangerous or committing a felony. Avon had an accomplice.
Except, counsel, there seemed to be some evidence that the police were concerned that he was involved with a number of burglaries that had occurred in Avon Lake.
That argument has been made. I don't think the record indicates that this individual had been involved. They didn't necessarily know the identity of the individual at that time, but there had been a rash of burglaries. That statement was made.
And the burglaries that happened, the individuals involved would steal a vehicle and then leave it.
Yes, that statement was made before the officers went out on patrol that evening. And I suspect you'll hear that fleeing from a police officer is a dangerous crime in and of itself. But the issue has to be whether continuing to pursue this suspect in light of a property crime alone and to continue this dangerous situation is warranted. The chase went through school zones, went through construction zones, driving over orange barrels. And so the ultimate issue with respect to the Avon defendants, Your Honor, is whether there is facts interpreted in the light most favorable to the plaintiff appellees from which a reasonable juror could find that the officers acted recklessly, wantonly, or willful. We recognize and admit there are factors under the Hoffman test that go in both directions. And we think that further supports the need to have a jury weigh in. A jury it's a high standard at this level, and it's a high standard at trial. And the jurors will be properly instructed, and they may very well find that there's not reckless conduct, but it shouldn't be taken away from the jury. And I would say with respect to the lower court's ruling, we think the court just made determinations of fact that violate Rule 56. The court found that traffic was light. If you watch the video, I did my best. I counted over 100 vehicles that this chase went through and passed. The court found that the officers drove at reasonable speeds without really any analysis to why those speeds were reasonable. With respect to the road
Did they
block,
slow down at intersections, for instance?
the
On the
officers
video.
did.
We'll watch the video, but.
Yeah, the officers did, as did the fleeing suspect at times. But I think too much the lens is focused just on the officers driving. And we would say the officers drove off the road and drove recklessly as well. But what's primarily the concern here is the suspects driving is dangerous.
Did Avon violate any departmental policies in the chase itself, or was it just Westlake?
Just Westlake, and I would say the overarching policy in Avon is that you need to discontinue a pursuit when it becomes unreasonably dangerous. We would say that policy, generally speaking, was violated. But with respect to specific policies, nothing as specific as Westlake. And so we think the recklessness issue with respect to Avon is a jury issue and should go to the jury. In fact, the court acknowledged that it was a closer call as to whether or not these defendants were reckless. Those close calls should go to the jury. I'll move on to the Westlake defendants, which is a very different set of circumstances, and one you will not find in any case. Under Rule 56, the facts of this case prohibit the conduct engaged in by the Westlake officers. That is, the policies that govern pursuit, and these are not just policies, they're police orders. The chief testified that these are the orders of the police and they are to be abided by. They explicitly prohibit an assisting agency, which is Westlake, from responding to, intercepting the path of, or getting into the path of the oncoming pursuit. And the reasons for that are obvious.
Counsel?
Yes.
You are starting your 5 minutes. If you want to
Okay.
save it, that's
I'll-
fine, or
I'll
you want to continue.
I'll take 2 minutes, thank you, just quickly to cite this out. And what these officers did is knowingly violate a policy. They drove directly at and into the path of this chase. And the defense primarily is that they had to make hurried and rushed judgments because they found themselves in the path of a chase. Well, that circular argument is problematic because the reckless conduct at issue is they should have never put themselves in the path of that chase at all. And as a lawyer who represents civil rights victims and victims of police misconduct, my fear is that if appellate courts start endorsing wholesale disregard of policies intended to protect the public and say, well, once you've violated all these policies, you find yourself in a position that is fast evolving and we can't second guess you, there really is no more. These questions are just taken from the jury.
But nonetheless, the Supreme Court has said that that's just one factor you looked at.
I agree. It is one factor, and that we would ask this court to look at the totality of the factors. One factor is violation of a policy, but I would say in Argabright, the Supreme Court case, and most of the other cases, they're talking about one policy violation. In Argabright, the assisting agency did join in the chase and then pulled off before the crash. Here, these officers drove directly at the chase, involved themselves in it, parked their cars in the middle of the road, created a roadblock, didn't put on their overhead lights, and then deployed stop sticks in violation of the stop stick policies, all with knowledge that a crash was likely to occur. And when the crash occurred and the truck flew into the bar, Officer Arcuri himself said that outcome was not surprising to him at the time. I'll reserve the rest of my time unless there's any questions.
I don't think so. Thank you.
Thank you.
Oh, no problem. Good morning, Your Honors. Jim Popson on behalf of the Avon appellees. As counsel noted, the parties devoted a significant portion of their briefing to analogizing and distinguishing the facts of various cases involving police pursuits in their briefs. And to the extent there are any questions about specific cases, I would do my best to try to answer them. But again, as plaintiff's counsel or appellant's counsel did, I want to focus my argument today on the standards themselves. The case law basically provides us with guidance to address 3 specific standards, which are willful, wanton, and reckless. And I think that is the focus here. And as counsel indicated, all of these pursuit cases are going to be different. There are not going to be 2 that are exactly the same. But the case law does provide some type of a framework as referenced with the Hoffman factors. In this case, applying the conduct of these officers to the 3 definitions of willful, wanton, and reckless, it is clear that these officers are immune from liability. And One of the things I want to make sure that we get out right away, because my time is limited. Immunity is a defense that a party is free from litigation. And it is the court's job to determine initially whether or not there is immunity and whether or not the defendants in the case are required to go through the remainder of the process of litigation. That's the purpose of immunity. It's not always going to be a jury question. And in fact, as we see from the case law precedent, as it relates to police pursuits, often it is not going to become a jury question. And the Supreme Court recognizes that. The Supreme Court has held that this is an onerous burden, that there aren't many times that this is going to get through. This is going to actually get to a jury. In this case, is one of those circumstances. The standard for recklessness, I don't think doesn't appear to be any issue that there was willful or wanton conduct here, that anyone intended any harm to anyone or knew what was going to happen and either acted or failed to act as a result. So I think the standard here that we should spend our time on is the recklessness standard. And we're talking about a conscious disregard to known risks that is unreasonable under the circumstances and substantially greater than negligence. That's the standard, substantially greater than negligence. And to say that the trial court didn't take into consideration the conduct of these officers and just summarily decided everything they did was okay, that's not what the court held. The court held, it specifically stated that possibly someone could make the argument in this case that police officers could have made a different decision at a certain point along the way. It's possible they could have, but that's negligence.
But counsel, and I agree with you, the court, wrote a lengthy opinion and went through a lot of things, but it almost seemed at points in time when you're making decisions whether that was reasonable, what the traffic was like, those are not decisions you usually make on summary judgment. I mean, that's usually what a decision you make after a trial.
In this particular case, let me give you an example. There may be a case where a police officer says, I was pursuing 45 miles an hour, I stayed in my lane, but nevertheless there was this crash. Somebody else says, that officer was going 90 miles an hour. He was doing this, he was doing that, he was out of his lane. He was driving recklessly. We don't know what the truth of that is. The court can't decide that. The court can't evaluate those factors. In this case, as counsel indicated, there's really no dispute about what happened here. There's no dispute about what the officers were thinking, what they were saying to each other. There's video evidence of this, and as the court describes it, it's crystal clear. You can see what happened here. There's not going to be a dispute about how fast they were going, about how many lights they went through.
But there is a dispute of whether the traffic was light or heavy.
Well, that is a dispute over characterization. It is not a dispute over the facts. The facts are right there. You can see the traffic in the video.
So if we find there were 100 cars, then that may be an issue of fact.
Well, no, it wouldn't. There would be 100 cars.
Well, because the trial court called that light, though.
Well, and to address specifically the 100 cars, if you count all the cars that went by this, you may well get to 100. But the allegations of the high-speed nature of this pursuit, there were all those cars were in the slow part of this pursuit. When you watch this pursuit, there's going to be a part where a significant part where the fleeing felon has his four-way flashers on and is going like 25 miles an hour through a construction zone, and there's cars everywhere. When we get to the high-speed pursuit toward the end of this pursuit, there is, in fact, light traffic, and you'll be able to see it. You'll be able to see it on the video. You can see it yourself. There's not going to be a dispute about what the traffic conditions were like in the 30, 40 seconds before the vehicle ends up losing control. And in the limited time I have left here, I want to get to those. The appellants in this case reference 4 factors that they think, from the Hoffman factors, that weigh in favor of allowing a jury to decide this case. And I wanted to address those 4 very quickly if I can. The first was the nature and seriousness of the offense. This is a stolen vehicle. This is a fleeing felon. Because it's a crime against property instead of a person does not obviate the duty of a police officer to initiate pursuit in that circumstance. So the crime that prompted the pursuit is certainly sufficient to warrant a pursuit.
It's just the reasonableness of the pursuit.
Right. So that's that factor. The second one was argued by appellants was the officers possessed a safer alternative. And what they say the safer alternative is to stop the pursuit. Well, Your Honors, if that's sufficient, that is true in every single pursuit case that results in a crash and injury to a third party. At some point, somebody could have said, call it off.
Well, but if it's a murder suspect, or if it's somebody that is in danger active, shooter or something, those would be things that you would look at whether or not the pursuit should be called off or not, right?
Those could play a factor in that. Certainly they could. But the point I'm trying to make is that in every single case, even all of the ones where summary judgment was granted, this factor is going to be present. It's not unique to this case. The third element of the 13 non-exhaustive factors that they referenced way in their favor is changing lanes. Council referenced that the police officers change lanes on occasion, and specifically referenced going off-road, having to drive through a ditch or over a curb during the pursuit. When you see the video, you're going to see that occurs long before the high-speed portion of this that occurs down the road before. After this happens, he has to drive through a construction zone. And again, changing lanes may be a relevant factor in a case if it's reasonably related to what happened. The officers changing lanes or driving over a curb had nothing to do with the end result of this case. Nothing to do with it at all.
Counsel?
Yes.
You are at 7 minutes and 15 seconds.
Okay, and the final factor is speed. And again, our Supreme Court has specifically held that speed alone is insufficient. In this case, the changing lanes have no factor, have nothing to do with what happened in this crash. Really, the only thing that they're saying is we shouldn't have been going so fast and pursuing this guy this long. That is present in every single case where summary judgment has been granted in favor of defendants granting this immunity. And this case is no different than those cases.
And we'll look at all of the cases, obviously, and we'll look at more probably, I'm sure. But were any of the cases that you cited or the other side cited were 5-mile pursuits?
Longer. Some were longer, some were shorter. They're all over the board.
Because I just was reading the ones that were shorter, so that's fine.
Schalkhauser, which was decided in this district.
Thank you.
May it please the court. My name is Frank Scaldone, and I represent the city of Westlake and the individual officers in this case. The opposing counsel bases his argument on a purported violation of policies. Well, the Supreme Court of Ohio has expressly and repeatedly held that the violation of a departmental policies or procedures do not establish an exception to immunity under 2744 or impose liability. At best, it's relevant to issue of negligence. Here,
it's an issue of relevance to whatever, I mean, that you would look at for possibly recklessness or willfulness or wanton, as well as negligence.
Sure, but here, I mean, the way it's stated is certainly is not correct. I mean, the Supreme Court has been very clear on that. Really, what the issue becomes here is whether, and for the individual officers, which is really the focus of their case or their best case, is the recklessness standard, which is probably at the lowest part of the willful, wanton, bad faith, malicious standard exception to individual immunity. So what they really have to determine is whether Officer Curry consciously disregarded a serious risk that in all probability would result in serious injury to the people that were inside the bar.
Was the question ever asked prior to this point of the officer, did you consider that there might be individuals inside these buildings, or were you only concerned with the traffic that you could see?
I think the officer wasn't at the time, again, and this is another thing the Supreme Court has held. I mean, you've got to pay deference to how quickly the situation is developing. It's basically 1 minute from when Officer Curry understands that car is on Detroit Road as opposed to I-90, where he starts to take action on there. So I don't think that was on the forefront. That was not on the forefront of his mind.
But I guess the question, was it asked? Was the question asked?
I believe it was asked, if my recollection is correct, that was his testimony, that was not on his mind.
See, I thought he testified that he did consider the fact that which way the driver could go, whether he'd go into the embankment or whether he might go over into the bar, restaurant, whatever you call it.
Or in that direction, I don't know if that's specific, but yeah, I mean, generally speaking, but as he's doing this under the circumstances, he's not considering people, and actually his testimony is that, you know, he would think that that's really not, he said at page 93 of his testimony, I'm sorry, at page 91 of his testimony, he testifies, we have to assume that the people in the building are safe. They're not out walking on the street, they're not crossing the street, they're not pedestrians. And that's under the cross-examination of the plaintiff. What I want to emphasize to the court, there really is no question that Brandon Pollock is presenting a grave danger to the public as he's recklessly trying to avoid the Avon police. And there's no real legitimate question that Pollock is racing towards some significant intersections at Dover Center and then down in Columbia in a built-up area where there's multiple shopping plazas. Anybody who's been there knows that. Certainly the officers who've been patrolling for many years know that situation. And there's no question that this is a quickly changing, quickly developing, altering type situation where he had 54 seconds before the pursuit ended. The Supreme Court of Ohio and the Ohio legislature have expressly endorsed immunity for political subdivisions and officers for cases exactly like this, because Officer McCurry and the officers here have a decision to make, and it's under a quickly developing situation where they can attempt to put spikes on the road and to try to slow down the pursuit and stop it, or allow the suspect to go into an area where there are intersections, where there are more people. This is not the type of situation where the officer is acting recklessly or with malice or with bad faith. He's making a determination ultimately to protect the public.
But
And
counsel, I'm sorry to interrupt you.
No, please.
This is my only opportunity.
Please,
to
no, I
ask.
want you to.
But I thought the whole point was that according to the policy, they should not have been intervening to begin with.
Well, again, the Supreme Court has expressly held that the policy is not going to demonstrate reckless conduct to strip the officers of immunity. And I could quibble with you, because I disagree strongly with the contentions that these policies were violated, as does everybody. And I would point out, as the trial court did, that the plaintiff's expert, and these are good attorneys on the other side, the plaintiff's own expert doesn't specify exactly what policies were breached. So I think that's a bit of advocacy, but more importantly, as a matter of law, the Supreme Court has held that that's not going to meet the exception for immunity. I mean, what I can say is ultimately there's a determination that the officer has to make on the ground. And there's nothing in the record here that indicates that there's some improper purpose. The purpose is to protect the public. And we can...
It feels like, counsel, that we are talking about proximate cause instead of immunity and instead of whether or not the actions were reckless. For instance, let's say Mr. Pollock was heading toward a major drop-off and police officers did something to cause him and his car to go over the end of that drop-off, and he deceased in his, for some reason, his estate may be sued, okay? I mean, I understand that we're talking about individuals who are in an establishment nearby who were injured, but when we talk about whether the conduct of the officer was reckless or not, aren't we also talking about what all the possible outcomes were based on the officer's training experience of what the actions were, not necessarily who it caused damage to?
My fear in that type of analysis, respectfully, is that the Supreme Court has expressly stated that you can't look at it from a perspective of 20/20 hindsight. You have to look at it from the perspective of the officer. And I think that is critical here because of the timing and because of the lack of anything in the record that would indicate that high level of culpability. Again, the recklessness standard is a conscious disregard of a serious risk that in all probability that injury would take place to somebody that would be in that bar. It just doesn't
Well, that's
meet that.
going back to her question, that you're saying they have to show that injury would occur to the patrons in the bar. And Judge Hensel is saying, do you have to demonstrate the specific nature of the injury or that injury could occur to individuals.
Right, that is much better than I said. And I don't know the answer to it, that's why I'm asking the question.
I think that there has to be, I mean, from the officer's perspective, there has to be that understanding. I mean, if those plaintiffs were pedestrians, then that would be very clear. But in his mind, I'm sure in the minute that is occurring with the car coming, he's not making that consideration. I mean, think about it. You really wouldn't think about the injury to somebody inside a building. I think the assumption would be that they would be protected.
Okay,
But
counsel, I'm sorry, but your time, I was allowing you to answer your.
Oh, I'm sorry.
You're a minute over, that's okay.
I would
I'll
simply
give you
ask the
another minute.
court to affirm the trial court's decision. Thank you very much for your time.
Thank you, counsel.
So I'll give you 4 minutes now.
Thank you. I'll address the Westlake defendants' counsel's arguments first and then proceed with the Avon. The discussion that I just heard between counsel and the court, that there were a number of factual issues that appear to be raised. What was in the officer's mind? What is foreseeable in terms of who might be injured if action is engaged in? Whether his conduct was reasonable or negligent or reckless. And while there is a bar that the court has to set, beyond which or above which it must go to the jury, we think that that bar is certainly met in this case. To not take this decision away from the community, away from jurors. With respect to Arcuri specifically, in terms of his knowledge or expectation, or a term like in all probability, which again I think is laden with fact-intensive inquiry, one of the issues that hasn't been discussed is there is an issue of fact as to whether these officers created a roadblock. And I haven't heard the defense in the lower court or in this court try to defend a roadblock as being something that is reasonable. It too is explicitly prohibited, and that's a factual determination. The court found that they gave the fleeing suspect a lane to travel down. That lane had oncoming traffic coming down. So the options that were given to this fleeing suspect were drive into oncoming traffic, crash into my police cruiser with no overhead lights on that is parked in the middle of the street while I run and take cover in the woods, or drive over these stop sticks, which everyone knows the fleeing suspect is going to try to swerve and avoid. Officer Arcuri had used stop sticks one other time before this incident, once on the freeway, which at trial the experts will talk about when these devices are used, and they're more often used on the freeways. And in that situation, the fleeing suspect swerved, lost control, and crashed the vehicle. But because it wasn't on a major thoroughfare in a residential and commercial area, that crash didn't result in an injury, it just resulted in a crash in a ravine in a median. So Officer Arcuri has used these stop sticks twice in his career. Both times the car crashed. He admitted at his deposition that he was not surprised that the vehicle slammed into and crashed into the bar. Knowing that's a likelihood, I don't think it's credible, but a jury should decide if it's not foreseeable that if a truck doing 80 miles an hour slams into a wood home, this is like a home tavern, and goes inside the bar, that people inside the bar are going to be injured. And the question of
But counsel, when you just use the word foreseeable, that's a negligence standard.
I think in terms of the proximate cause, I think foreseeability is a relevant question. I was talking about it in the context of Judge Hensel's question about proximate cause. So I think the proximate cause question is too laden with factual inquiries. With respect to the policy violations, the Supreme Court does say a policy violation by itself will not, as a matter of law, amount to recklessness. That's not what we have here. We have policies violated at every step. I mean, we basically have these defendants disregarding every rule in the book that resulted. Rules regarding pursuit, rules regarding stop stick placement, etc. They never should have been in that position, and that decision by itself was recklessly made. Moving on to the Avon defendants.
You have 30 seconds.
Thank you. The safer alternative, I would just, not saying that I'm trying to correct my colleague, but the safer alternative in this case is Avon knew they had a confederate of the fleeing suspect, an accomplice in the theft, in custody. So yeah, there's always got to be a balancing. Is the safer alternative to discontinue this chase yeah, that's a question, but in this case, one of the reasons it discontinued is they had somebody else in custody that they could interrogate to recover this property.
And your time is up.
Thank you. Thank you, Your Honor.
Thank you to each attorney and to the respective sides. We will take the matter under advisement. We will issue a written opinion that will be sent to all sides, as well as we will release on our website in the Supreme Court. And please stay safe out there today.
Thank you.
Thank you.
Thank you, Your Honor.